At any moment in the United States, millions of people are following the law without realizing how much of it is built on silence. Not silence as in secrecy, but silence as in gaps, places where rules stop speaking. These quiet spaces shape daily life more than most Americans ever notice. The core question is simple but unsettling. If laws are meant to define right and wrong, why do so many outcomes depend on what the law does not clearly say? In courtrooms, contracts, and institutions, decisions are often guided not by bold statutes, but by narrow wording and unspoken boundaries. These are commonly called loopholes, though that word oversimplifies what is really happening. Most Americans assume laws work like switches, legal or illegal, allowed or forbidden. But the U.S. legal system does not function that way. It operates more like a maze built over centuries. Federal statutes, state codes, administrative rules, and judicial interpretations all overlap. Where they fail to align perfectly, space is created. That space is not accidental. It is a result of compromise, history, and legal caution. What makes this difficult to see is that loopholes rarely announce themselves. They exist in footnotes, exceptions, definitions, and timing. They do not require breaking the law. In many cases, they depend on following it precisely. Most people never notice this detail because the system appears orderly on the surface. Forms are filled, procedures are followed, outcomes are issued. Yet beneath that order is a structure that quietly rewards those who understand how silence can be used. What happens next is rarely discussed outside legal circles, but affects employment, housing, money, and responsibility itself. To understand it, the story must begin with how American law is written. Every law begins as language. In the United States, that language must survive negotiation, political caution, and future uncertainty. As a result, lawmakers often write rules that are intentionally narrow. They define what is prohibited, not everything that could possibly happen. Anything left undefined is not automatically illegal. This is where the first kind of loophole appears. If a law bans a specific action using specific terms, behavior that falls just outside those terms may remain lawful. Not because it was approved, but because it was not anticipated. Courts are not allowed to invent prohibitions. They interpret what exists. Most people never notice this detail because laws are presented as complete solutions. In reality, they're frameworks. Agencies then create regulations to fill in details. But even those regulations must stay within the original statutory boundaries. When they do not, courts strike them down. Timing also matters. Laws apply based on when an action occurred, not when its consequences became visible. This creates legal gaps where conduct is judged under older rules, even if newer standards exist. The system quietly works like this, favoring precision over intuition. Another overlooked factor is jurisdiction. Federal law does not automatically override state law unless Congress clearly says so. States can define rules differently, creating uneven enforcement across the country. What is restricted in one state may be unrestricted in another, without violating federal authority. None of this is hidden. It is written openly. But understanding it requires reading laws the way courts do, not the way headlines summarize them. What happens next moves beyond language and into interpretation, where meaning becomes just as important as TE. Once a law exists, it must be applied. That task falls largely to courts, and courts rely on interpretation. Judges do not ask what feels fair. They ask what the words reasonably mean within legal tradition. This creates a second type of loophole, interpretive space. When a term is vague, courts look to precedent. If similar language was interpreted narrowly in the past, that interpretation often continues. Over time, this can hollow out a rule without changing a single word. Most people never notice this detail because court decisions do not rewrite statutes. They clarify them, but clarification can quietly limit scope. A law intended to cover many situations may end up applying to only a few. Another factor is burden of proof. In civil and administrative systems, responsibility often depends on who must prove what. If a law requires an agency to demonstrate harm or intent, and that standard is high, enforcement becomes difficult. The rule exists, but practical accountability fades. The system quietly works like this in compliance-heavy areas like contracts and regulations. Entities that understand documentation and timing can stay technically within bounds while avoiding consequences. Importantly, this does not require bad faith. It requires awareness. Courts do not punish outcomes. They evaluate processes. What happens next is rarely discussed because it involves structure rather than behavior. To see it clearly, attention must turn to how enforcement actually happens. Enforcement is where laws meet reality. In the United States, enforcement is not automatic. It depends on agencies, resources, priorities, and procedures. A law without consistent enforcement becomes symbolic rather than practical. One overlooked detail is discretion. Agencies must choose where to focus. They develop internal guidelines that are not laws, but shape outcomes. If a situation falls outside those guidelines, it may receive little attention, even if technically covered by statute. Another gap appears in penalties. Some laws impose consequences only after repeated violations or formal warnings. This creates room for behavior that remains within the warning phase indefinitely. The system quietly works like this, prioritizing compliance over punishment. There's also the issue of standing. Courts require a specific party to show direct harm before hearing a case. If harm is widespread but diffuse, no single party may qualify. In those moments, a rule exists without a path to challenge violations. Most people never notice this detail because enforcement failures look like inaction, not design. But the design is procedural. It values restraint and due process, sometimes at the cost of clarity. What happens next moves into an area many Americans interact with daily, often without realizing how much legal silence shapes outcomes. Contracts are private law. They operate within the public legal system, but are governed by their own logic. In the United States, courts generally enforce agreements as written, even when outcomes seem uneven. This creates one of the most common loophole environments. If a contract clearly states a condition, and that condition is met, courts rarely intervene. Silence within a contract can be just as powerful as explicit terms. Most people never notice this detail because contracts are long, technical, and normalized. They assume fairness is implied. Legally, it is not. Only what is written matters. Another factor is default rules. When a contract is silent, courts apply standard assumptions. Skilled drafters know these defaults and can rely on them without mentioning them at all. Timing clauses, notice requirements, and definitions quietly shape responsibility. Missing a deadline by a day can change outcomes entirely without any moral judgment involved. The system quietly works like this because predictability is valued more than flexibility. Courts aim to preserve reliability, not correct imbalance. What happens next is often misunderstood as manipulation, but it is better described as navigation. To understand it fully, the final piece is perspective. Loopholes are often described as tricks. In reality, they are reflections of a system built on limits. American law is designed to prevent overreach. In doing so, it accepts underreach. Most people never notice this detail because the system functions well enough to appear complete. Roads are regulated. Transactions proceed. Disputes are resolved. But perfection was never the goal. Stability was. Education plays a role. Legal understanding is unevenly distributed. Those with access to expertise see boundaries others do not. This creates unequal outcomes without unequal rules. Importantly, closing one loophole often opens another. Every clarification narrows flexibility somewhere else. Lawmakers are aware of this and move cautiously. The system quietly works like this because it must balance freedom with order. Silence is not always a mistake. Sometimes it is intentional restraint. What happens next is not a solution, but a realization. When Americans think about law, they often imagine control. In reality, the U.S. legal system is more about definition. It defines what is clearly prohibited and leaves the rest to choice, judgment, and consequence. Loopholes are not holes in a broken structure. They're spaces in a careful one. They reveal where certainty ends and interpretation begins. Understanding this does not require cynicism. It requires attention. Laws speak loudly about some things and quietly about others. Both matter. Most people never notice this detail because silence feels empty. In law, silence is often deliberate. The system quietly works like this, shaping outcomes not through force, but through boundaries. And once those boundaries are seen, the system looks less like a rule book and more like a map, one that shows where the lines are drawn and where they're not.